wholesale change that's happened, but what do we think is going to happen from a tax standpoint, and what do we need to maybe not do now, maybe do now, maybe do, later on, depending on what happens, but go ahead and get educated on that. And then we'll talk about some strategies and ideas and run through a case study. So to start with, why we're preparing you for this now, and think about the difference between an OR and an ER. And when you think about medical malpractice, it often happens in the ER, but very rarely happens in the OR. And there's a very good reason for that. What happens in the operating room is planned. And people get the right experts in the room. They put together the right plan. They're not acting frantically. There's less adrenaline involved. And because of that, you find fewer mistakes. In the ER, though, when people are just acting off the cuff, it's easy to go in the wrong direction. You might even have the wrong doctor in the room, or, a regular ER doctor might have to do something like, deliver a baby, which is not what they do every day, or conduct an emergency surgery. And so when we think about that back to your finances, we really want to put your finances in that OR type of category and direction. And when you think about the blue wave and possible tax changes and how that may impact your estate planning, we don't know if and when some of these things will get passed, but it might be a very timely event. And here's what I mean by that. Let's say they pass a law that changes some things and you need to make some changes to your plan in October of 2021. Well, it may very well be that you need to make changes by January 1st of 2022. And when I think about the different areas that we help folks in, investments, for example, whether you do something with your investments in December of 2021 or January of 2022, odds are there's not a huge difference. But when you think about estate planning and tax planning, there's a big difference between December 1st and January 1st. There's a big difference between December 31st and January 1st. And so what we want to start doing is educating and preparing on what decisions might we make if changes happen, and if we have to do things quickly in the future to better prepare for our future and prepare our estates for those we love. And so with that, I will let Amber take us through some of the basic terms of estate planning and make sure we've defined all these so we can then move on into how they could be impacted. Amber?
Thank you so much, David. Good afternoon. So while most people probably know what it is, we just want to, again, have a baseline for understanding with respect to these terms. So wills and trusts, we know what they are, but they're both estate planning tools that can help ensure that your assets are protected and given to your heirs besides your spouse, which is generally not an issue. A will becomes active at your death. The trust is active the day that you create it. And the will must go through the probate process where a court officer, the judge, examines it and says if the will is valid, and trusts are not required to go through probate when you pass away, so they cannot be contested. The next word we want to define is basis. So cost basis is the original value of the or purchase price of an asset that you have, an asset or investment for tax purposes. So the cost basis is the value used in calculating your capital gain or loss, the difference between the selling price and the purchase price. And of course, that comes into play when the asset is sold or a gain or loss is realized. The next term would be step up in basis. So a step up in basis is a readjustment of the value of an appreciated asset for the purpose of inheritance. So when you give something to someone at your death, that individual gets a step up in basis, meaning the higher value that that asset has at the time of your death becomes their basis, so that it can assist them if they have to sell it. You don't want them to have your original purchase price as their basis, because then they'd have a huge capital gains tax. And so it's adjusted at the time that you die so that whatever the value is at that point, that is their basis and they get that step up.
Amber, do you mind if I interject with just an example of that so I make sure we're all understanding it? So just the easiest thing, let's say you put $100 into an S&P 500 index, and that $100 grows to $120. Well, now if you sell that, you're going to have a $20,000 capital gain, whether it be long-term or short-term, depending on how long you owned it. But if you hold it, pass away, and your children inherit it, they can now sell it at the $120 point and not pay any tax. All right, back over to estate tax. Our favorite tax in the world, estate tax, right?
Right. So the estate tax is the, I guess, levy or tax that is based on the current value of your assets at the time that you die. And so federal estate tax is levied on assets in excess of $11.7 million. And then there are some states that have their own individual tax. So to illustrate, if you have an estate that's worth $13 million, and as of 2021, the exclusion limit is 11.7. So anything above that 11.7 is taxed. So with the $13 million example, the federal estate tax would be owed on just the 1.3, just the amount that's above the $11.7 million.
Yep. Sorry, I was going to try to whiteboard that, but I'm not that smooth with my technology. So go ahead.
No problem.
And this is your kids' favorite one because they want you to give them your money.
Right. And then the gift tax is a tax that applies to an individual giving anything away to another person. For it to be considered a gift, the receiving party cannot pay the giver the full value of the gift. They may pay an amount less than the full value, and it potentially could still be considered a gift. So the annual gift exclusion per recipient is $15,000 per recipient per year, and the lifetime exemption for a single donor over your life is $11.58 million. Gifts don't count. It doesn't count if you give to your spouse, who is a U.S. citizen, political organizations, and there are certain other exemptions from that particular tax.
You said something key there. You said that is a U.S. citizen. What could be an issue if they're not a U.S. citizen?
If the asset no longer is in the United States, I'm not sure why they want. If it's a U.S. citizen, then they're assuming that that individual is subject to our taxation. They're subject to various other levies that might be issued against that person. If they're not a U.S. citizen, then if that gift is given to that person, they might not have to do. The U.S. doesn't have any sort of control or jurisdiction over those funds and over that individual to ensure that if anything is done with that or whatever happens with that asset, that they can be able to get some money from them later for it if it's sold.
Gotcha. Cool. All right, so let's talk about what might happen now with this blue wave. And I heard one time the Biden tax proposal called the Life Insurance Producer and Estate Planning Attorneys Full Employment Act, because it's changing so much that there's going to be a lot of action happening. And the strategies we talk about, pretty much all of these will work even if you don't have a taxable estate, except for some of the stuff we're going to get into about irrevocable trusts and things like that for people that are near or above the exclusion. But all this other stuff will work, just to give you all some context. But first of all, possible changes. The first one, and I think this is pretty unlikely, but it's that nothing happens. And if nothing happens, I think back historically looking at the early years of the Obama presidency, I really personally thought with the way he campaigned that they'd be raising taxes a lot more than they did. And he was sitting there with Congress having a super majority. Well, what happened was he inherited a weak economy, very much like what Biden's got, although more of a financial crisis than a health crisis, creating that weak economy. And then the Congress chose to work on other things. Back then it was health care. So, now they may choose to do this, they may not. And then after the midterm elections, when Congress flipped, he was no longer going to be able to get these things through Congress. So that may happen where literally nothing happens. If that is the case, current tax law is set to sunset on January 1st of 2026. And this is a date I thought was really interesting because we all know it's out there, but a lot of our clients and a lot of the people we talk to have not done the kind of planning already that they probably will in 2025 as the sunset approaches. And, oops, sorry. Okay. But if nothing happens, it still does sunset, and at that point in time, the state tax exclusion goes about down to where Biden's proposing going ahead and taking it, which is right in that $5 to $6 million range. I think he said 5.8, but until it's out, hard to say exactly. But then, Amber, why don't you tell us about what proposed change is in the Biden policy and how that can impact things?
Okay, so there are a few that we have bulleted here that might be relevant to decisions you make with regards to estate planning and overall investing. So one is an increased capital gains rate. So removing the preferential rates for long-term capital gains for taxpayers with incomes over $1 million. And that might impact where you want to have your assets held. If it's an appreciable asset, that this might matter for you, and you might want to talk to someone like David and try and figure out what to do with it so that you can maximize the possible benefits now before January 1st, 2026. The next one will be lowering the estate tax exclusion. So right now, as I mentioned before, it's at 11.7. Effective January 1st, it would be back down to 5.8, but the proposal doesn't say, they haven't said whether or not, Biden proposes the 5.8 or even going back to the 2009 level, because I think in 2009 it was 3.5 million, which would be a significant decrease. So we're not sure where it would be or if it would happen at all, but we know it automatically would change January 1st, 2026 by virtue of the sunset.
With that exclusion, talk to them about portability and what that means, because let's say it goes back to 3.5 or 5.5. You might have people that are, let's say it's 5.5 just to make it rounding easy. You might have people that are worth 8 or 9 million and not worth 11 million, but they still need to do planning if portability goes away. So what is that?
So I'm not sure what you mean by as far as the portability.
The spouse automatically inheriting the other person's exclusion.
Oh, okay. So I mean, there's a ton that you can do. The spouse, you can separate the trust. Your spouse would be able to inherit without being subject to taxes in general, because there's an unlimited marital exclusion. So you can set it up so that certain assets that you feel as though, or you and your advisor, or you and your CPA feel as though would be better just given directly to your spouse, so that they're not subject to those particular taxes. So it's just really setting it up in a way that you can maximize the tax benefits. So even if you are above that 8, there's a way to do it where there's a certain amount that gets taxed, and then there's a certain amount that is passed on to your spouse tax-free. And then you can, it's not too complex, but it can be done in a manner to protect your assets so that you're not subject to the 3, for example. If it was the 8, that 3 million, you can figure out, not even 3. If it's 5.8, it would be 2 million that would be subject to the higher tax rate. There's ways that you can manage it in order to reduce that tax for that 2 million that would be subject at that point. So the next one would be the step up in basis. So as we mentioned before, the step up in basis is you're allowed to, right now, the higher value would be what the basis would be for the individual who inherits, for your heirs. However, in this proposed change, Biden is essentially proposing to eliminate the step up in basis, which would mean that whatever your original purchase price for the asset was, it would carry over to your heirs. So they tried to have this some years ago, and it didn't really work. And so it didn't end up being implemented. But essentially, it's not clear how that would impact your estate planning or the estate tax. But if there's no step up in basis, that means that essentially your heirs would have to, at the point that they try and transfer, they would have to pay the tax for the value that asset appreciated. And so I don't know. I mean, we've been reading a lot of articles and different things about that. I don't know if that's going to happen because that would be a significant change, I think, and there's going to be a lot of arguing about that. Just from a basic equity standpoint, if you're inheriting something, or if your children are inheriting something, should they have to pay for that entire appreciation? It's kind of unfair because the individual who is the heir is not necessarily asking for the asset. So why should they have to pay for that because someone decides to give that to them?
Well, in the lower,
Go ahead.
yeah, go ahead. The lower estate tax exclusion, that impacts a small percentage of Americans. Those fortunate enough to have estates worth that much. This step up in basis, I mean, you're going to all the way down to almost every middle class family in America is negatively impacted by that. So it'll be interesting. That to me is the one that jumps out as a, oh my gosh, kind of moment.
Yeah, and I just don't think it could be tossed around. I just don't think that they're going to do that. I mean, I would hope not, because like you said, it can impact everyone. I mean, it could be a small property that, your family had that they sent, and that's the only asset that your grandparent or whomever had. Who wants to try and put that burden on an heir? So I think it'd be interesting to see whether or not they actually do that. I hope not. So there are a couple others. So they're expanding Social Security, potentially expanding Social Security tax to earnings above 400,000, increase the top rate tax rate for individuals with income about 400,000 from 37 to 39.6%. And then I think, was there anything else there? I think that's pretty much the main ones that everyone's been talking about that might impact how people choose to invest and how they choose to set up their estate plans.
Yeah. Well, and the truth is, this is a 1-hour presentation, and we could go on for 4 hours if we talked about all of them, but these are really the biggest ones that, really jumped out. And these are the kind that would require either fast execution or significant changes in your plans too, I think. So, all right, let's go on to our wonderful case study. So we have Joyce and Alvin here, and I will tell you all a funny story about Joyce and Alvin. Juliana has a new person she's working with in our marketing department, and when we first made this presentation, she put 30 or 40-year-old people on there, and I said, we got to get somebody older here for doing estate planning, the wrong folks. So Joyce and Alan are our typical folks going through this. That was really kind of funny.
Wait,
so let's
David,
talk about.
But
Yes,
estate
ma'am.
planning isn't just for old people; it's for everybody. It's so important, even if you get married early, to have an estate plan, because you just never know. That's what I heard.
That is a great point, and yes, and in fact, looking at the people on this call, knowing that most of them also have children and grandchildren that they care about. Great public service announcement. Thank you, Juliana, because
Thank you.
I tell you what, if you have kids and then your kids have grandkids, gosh, they definitely need that estate plan. Imagine what could be sadder than a young parent passing away and you don't have this proper trust and estate position set up for minor children. So great point. All right. However, Joyce and Alvin are in their 60s. So there we go. All right. So here's their situation. Their net worth is currently below the current exclusion, but above the proposed one. Okay. They have multiple types of assets, and watch this, because this is going to go into what we want their kids to inherit. It's going to go into what they give to charity, and it's going to go into how they handle things like the step-up basis. So they have taxable investments, just regular investments in a taxable account, a consolidated stock position. So that's the same as that taxable investment, but maybe they paid into their employee stock plan or own a business, and it's a significant portion of their net worth in one stock position. They have IRAs, and they also have Roth IRAs. They do have charitable intentions, both while they're alive and in their estate. And then, Amber, I like this one. You came up with these clever names. So tell us about Millennial Peter Pan and Responsible Wendy.
So I very frequently have people come in the office who have one child who they feel is less responsible than the rest, doesn't necessarily want to grow up. And so the Peter Pan or, just the idea of not being an adult, even though you should be an adult. and Peter Pan not wanting to grow up.
All right. And then, of course, Wendy's responsible with 3 kids. So we got, the minor kid issues that Juliana brought up there. So cool. And then they have, and this is big when we talked about some of the other stuff, especially the step up in basis, a 89-year-old parents. And, right, we used a net worth of $10 million, but, it could be anything, and a lot of these principles change it. So let's go into some strategies on this. So the first one I was going to talk about is, what does it tell me when I hear that they're charitably minded, and how does that impact their estate plan? And then Amber will give us some trust strategies. But, when you're charitably minded, the first thing that comes to mind here is, of these different types of assets, which ones do they want to give to charity? And in their lifetime, what jumps out to me is, if possible, let's give some of this consolidated stock. It is going to be a position we probably want to diversify, and if you give appreciated assets, you do not have to pay tax on that. Now, if they're over 72, we might change that and do qualified charitable donations from their IRA, but remember I said Joyce and Alvin are in their 60s, so I'm talking about giving this stock. Now, when they pass away, I want them to give the IRA, and the reason I want them to give them the IRA is that is a taxable investment to the heirs, and they now, with the stretch, are not able to stretch it with the Secure Act. And so let's say they're leaving $100,000 of their estate to their church. Well, the IRA is a much better position to leave than that taxable account or the consolidated stock position, especially assuming the heirs get a step up in basis. And then the Roth IRAs are tax-free. So there's that aspect. And then there are charitable trust type things they could do. So there's 2 routes I go with that. And one is kind of a donor advised fund type thing, which is I want to give the money and get a deduction now and then really give that money, all of it, over the next 10 years. And what's great about a donor advised fund is, let's take this consolidated stock position. It might be hard to send shares of stock to a charity, but it might be really easy to just give a lot of stock to the donor advised fund and let it send a bunch of different checks places. And there are also strategies of, this is sort of the I want to keep it but give it strategy, where you put the money in a type of trust, or they call them pooled income funds, which are kind of an inexpensive retail way of doing this, where you go ahead and put the money in, again, probably the consolidated stock position, and get income back from that for the rest of your life. And then which creates a deduction now, which, back to what years do you need the deduction, depending on if they're working or not, or other things that will show. And, a great thing would be, older parents, if, they pass away and they get a ton of this income and a ton of it's counted as taxable income, maybe you do something like that in that year. And the reason it would be counted as taxable income would be is if that step up in basis goes away. But you can give money out, you get income back, and basically it goes to the charity at the time of your death. And so think of it in a few categories. One, what should you be giving? Part of it's different if it's now versus at death. And then second, do I want to do any of these other types of strategies to really leverage that up? So let's go back to the case study here. And from this, our next strategy, and Amber, you can talk about this. Why would somebody want to move the money out to an irrevocable trust? And that really jumps here because of this net worth aspect. So Amber, tell us about that.
So in my mind, there are generally 3 main reasons why you would want to set up an irrevocable trust. If you have some more complex planning, if you're above this tax rate and you want to try and minimize your estate tax, you might want to do it. But if you are an individual who's becoming eligible for a government program, so disabled beneficiaries on Medicaid or supplemental Social Security income, they have certain requirements, so that person might have to do certain things in order to not lose these government benefits. And the third reason is to protect your assets. So there are some individuals who are concerned with protecting their assets from creditors. And so this would usually require setting up a trust that's irrevocable. So some of the irrevocable trusts that we talked about, or David mentioned some, but there are grantor retained annuity trusts. There's a name for every kind of possible trust. It just depends on what you want to do. But when you do set up an irrevocable trust, the thing that people need to be aware of is that at that time, that it's set up, that the trust is going to be subject to a higher tax rate because it's irrevocable. Whereas if you have a revocable trust, it's not subject to that because it's still, the IRS looks at it as though that revocable trust is you. It still has your social things like that. The irrevocable trust is a separate entity. And so it has to be, the trustee has to be separate from you. You can, in some instances, depending on the type of trust, be a co-trustee so that you can still kind of manage the assets a little bit and how things are done. But the goal is for the irrevocable trust to shelter income and assets. So you're supposed to have some sort of separation. So those are the main three reasons that you do it. You can move assets over there. For example, the one that David gave with respect to charitable giving, you can have trust set up to give you income, and then it can pass on in a manner that's tax-free. So there are tons of ways to do it, just depending on your goal. One particular one for many of the clients that we have, there are individuals who frequently face lawsuits. So like surgeons, architects, real estate developers, and setting up an irrevocable trust is a way that they separate themselves from their assets so that if someone sues them, the example that Dave gave earlier was the ER doctors. ER doctors are generally independent contractors because there are so many mistakes, or there can be so many mistakes in the ER. And so they have to carry their own insurance. They have to carry everything separate from the hospital. They're not employees. So if someone sues them for a mistake, they have to be liable themselves. So if they don't have the proper insurance, if they don't have those things, individuals can go after their assets. And so setting up an irrevocable trust separates them in that job that they do from their assets so that people who might sue them can't necessarily go after everything that their family has.
Great. Thank you so much, Amber. All right, let's come back to our good friends here, Joyce and Alvin. So, you know, they've given the right money to charity now. They've protected some of their growth from future estate taxes. We still have this millennial Peter Pan hanging out here. And, you know, I'm interested in this from two angles. One, what can we do to protect Peter Pan from Peter Pan? And then second, you know, and I'd be interested in your experience from this, Amber, whenever you treat children differently. So, you know, if I'm treating Wendy differently than I'm treating Peter Pan, there's some emotions that go with that. And there's some soft side family conversations and, you know, possibly even family meetings and things that need to go, you know, on the soft side of things to make that all work out. So let's talk about this Peter Pan child and what sometimes can be done. Okay,
awesome. So I like they're called spendthrift provisions within the trust, right? So it's to prevent certain beneficiaries from receiving their inheritance all at once. And this might be that because they'll blow all their money and assets in a short period of time. So this means that the beneficiary's inheritance is meted out in portions over an extended period of time, say 10, 20, however many years that you outline it. They have no right to the money and can't spend it before they actually receive the distributions. They can't go to the trustee and say, hey, all that money is being held in there for me. Nothing can be done. So they can only get it when it's distributed to them. So then creditors or anyone else who they owe money to can only receive the money that they've actually received, not the remaining money that's in the trust for their benefit. So it prevents them from spending all of the money and make sure that they get distributions throughout whatever the duration of the trust is. So for example, if you leave $5 million to your favorite nephew, and the trust generates about $250,000 in income that's paid out to him annually. But the trust retains control of that $5 million in assets that produces that income. He can't pledge those assets to anyone as collateral for debt. He can't do anything. They're out of luck if he has a mortgage for a house. They can't go try and take that money out of the trust because it does not belong to him. It belongs to the trust. The only thing that they could get is that income that's distributed to him on an annual basis. So the principle of that, in that example, the principle stays in place. And it is an odd and awkward conversation if you have one child who is the responsible one and one child who you feel like is not, and how do you explain to them that one might be able to get their money outright. Now, I think that you can do, it's not a bad thing to prevent any of the children from getting all of their money outright, because just like in the example, if once that money is distributed to them, it is subject to creditors, spouses who they're in the middle of getting a divorce from, anyone who wants to, once the money becomes theirs, then it can be attached by creditors or anyone else. So it might be a good idea to leave the money in there for both of them, the responsible and the not so responsible child, and have it be meted out over a time period to make sure that they always have access to funds later. So maybe just because of Peter Pan, you might treat Wendy the same way. Wendy might do something different with it and it might last longer for her. But then that way, Peter Pan is not upset with Wendy for the rest of his life because she gets all of her money and he has to wait.
And Wendy goes out and buys a new house, and Peter Pan's sitting there still renting an apartment.
Right.
Yeah. Well, and I've heard this a lot from clients too. I mean, the fact that Wendy has children and Peter Pan doesn't, sometimes people want to give to the grandkids in the estate, and that's kind of a roundabout. Sometimes people do not want to do that. But I would say with this, and, Amber, you might know some precise stats on this. I think in general, average inheritance is spent within 18 to 24 months. And also, even amongst uber wealthy families, usually if there's a first generation that makes the money, kind of a second generation sort of sustains it, a third often dwindles it. So usually you can look out about 3 or 4 generations. A lot of the time that wealth is not there anymore unless it's people that earn it on their own. And so, what a shame that is when you think about how we could use all this stuff to bless people instead of have it dwindled. So.
Absolutely. Yeah, I mean, I think that this is a good way to do that, because you can outline what it can be used for, and how. Now, I mean, there's the most dreaded term in law school is the rule against perpetuity. So it just means how long the trust can last. Like, it can't go on forever and ever. At some point, it's going to have to expire. But you really can, as the creator of the trust, make sure that it's used in a certain way. You can have your fiduciary. Most organizations have a trust department. You can have a third party try and invest the funds that are in there to make sure it's generating income, and have the same people who are looking after your money and during your lifetime look after it for your children, and make sure that it grows and that it creates income that they'll be able to use in your children's children, et cetera. So that's part of trying to make sure that everyone works together and comes up with a plan for all of those situations, because it actually can be beneficial for both Wendy and Peter Pan.
All right, so let's jump to the next strategy here. So in recap, we talked about some charitable strategies, how they might want to do that. That can be more important post-Blue Wave, but important even without it. Talked about irrevocable trust, which certainly a lot of creditors and benefits, and then other reasons to do them even without changes. But a lot of folks on this call are going to be over the threshold if some of these things go down. And then we talked about this next one, taking care of millennial Peter Pan, and, public service announcement, back to what Juliana was saying. Those are so important if you have grandchildren that are still minors, for example, to make sure their parents have put those things in place for the financial resources if something happens to them. And then let's go to now our last strategy we're going to talk about on this call, the 89-year-old parents. So we're going to call this multi-generational planning with parents. So, in general, a good investment advisor for an 89-year-old parent is probably not going to recommend making many changes to their portfolios simply because of step up in basis. And, if you have some consolidated stock or some appreciated stock, it makes all the sense in the world to just hold on to that stuff and let your kids inherit it. Now, if you change this, and, some of you on the call are coming to mind where this applies, your kids are possibly in a higher bracket. And so if they change it and step up in basis goes away, think of it this way. If Joyce and Alvin are still working or have a high level of income, their kids are working and have a high level of income, but mom and dad at 89 years old are living on dividends and Social Security, they might be in a much lower capital gains rate than if their children inherit this money. And if you think back to what Amber said earlier about the capital gains rate possibly changing for people with the income of over $1 million, think about this case. If they're worth $10 million and they have to recognize all the gains in 1 year, that year, Joy and Alvin will probably have an income of several $1,000,000. And it's by default of having to recognize those capital gains. And so even if they're in retirement and not there, so it could really kind of hit you. And so the big one here with multi-generational is possibly re-diversify the portfolio. And then the other thing I would think about, especially when you get to this age and you have the younger kids and grandkids, start a gifting strategy. Help those kids go to college and it really invest for their future and things like that. And being intentional about those gifts can really be a blessing. Amber, do you have anything to add on the multi-generational side?
Yeah, I mean, the only thing that I would probably add to that is that it needs to be intentional and systematic. And David and I talked last week when we were preparing for this presentation, and he was talking about having a brand or a theme for the family. And so I think that in planning for a multi-generational family, what is the theme for the family? What's the process of communication, collaboration, and designing the plan to think of all of those generations? It can't be that you plan one thing and then your kids go plan something else, and those things aren't consistent. Like if you have the conversations and come to someone like David and sit down and say, okay, this is what we want to happen, then you can receive the input on, okay, maybe I need to move this over here. Maybe this is something that my son needs to do with his investments to try and make things easier, so that both hands know what one hand knows what the other is doing, and it maximizes the tax benefits, it maximizes the inheritance for the grandkids, and all of those things are considered.
All right, excellent. So let's talk about next steps and then open up for questions here. So, what I would say is absolutely the next step is, unless you feel really confident on this, take inventory of your situation. And it's amazing how many people don't know where all their money is. Even people of high net worth, a lot of times will be very fragmented and haven't really pulled it all together. And a lot of times in coming up with a good wealth management strategy, the first thing to do is get organized, right? You can't plan unless you know what you're working with. And then once you're organized, I would say you can determine if you're potentially impacted by one or more of these changes. And if you are, let's start having conversations about what we might want to do when these happen, because I will tell you, back to the difference between investments and tax. And when I think of wealth management, we're really helping with investments. There's estate transfer, there's tax mitigation and cash flow strategies, there's asset protection, there's charitable giving strategies. And all of those have some type of time increment, usually revolving around the calendar with the exception of investments and asset protection in a lot of ways. But if these happen and you have to make changes fast, do we know what those changes might be, and how are we comfortable with them because we sat with them and thought about them over time? And then, even if you're not impacted, determine if your estate and investment plan is up to date. I bet there are some of you guys hearing some of these things that might go, oh yeah, I do need to change the beneficiary on my IRA to leave money to my church versus putting that in my will. Or, I hadn't really thought about it, but that child might need some protection from themselves. And then on fourth, if any of those raise a need for you, seek professional help. And Amber is a great, amazing resource on the legal side. I love the holistic way she works with people, as well as having a little background in business law as well as estate planning. We are here to help kind of coordinate and facilitate the whole situation. And then also other teams of professionals, a good CPA, good property and casualty, just making sure this is all looked at. And so with that, I will open up to the audience for questions. Here's a little QR link to contact Juliana if you want to set up a meeting with either myself or Amber. And with that, who, if anyone, has some questions for us?
And you can also unmute yourself to ask the question or put it in the chat function, and I will read it out loud.
David, if there's no questions, that means we were really thorough, weren't we?
I have a question for you.
I agree. Yes.
So my husband and I obviously were a little bit younger. but it is important. So I've heard about getting an estate plan. Do you think it's worth getting a trust and an estate plan? And can you get a trust before you have kids, or should we do it afterwards? I think a lot of it is just kind of really confusing for myself personally.
Oh, okay. Okay. So you do need, so a trust will be included in an estate plan. So everyone has an estate, no matter how much money you have, whatever you own is a part of your estate. You might not need a trust. Sometimes a trust is, depending on the situation, what assets are there. Sometimes it's more of a headache than you need. Sometimes, for example, with whatever investment vehicle you have, you always name beneficiaries. So those things don't necessarily have to go through probate if you have it specifically named. And any beneficiary designation you have for your accounts is going to override whatever's in your will anyway, because they specifically say who they go to. The will just says if there's anything outside of those things that have a designation specifically, that this is what you want to happen to them. So if you don't have a ton of assets that you're concerned about having to go through the probate process and be subject to creditors, then you might just be able to figure out a way to do it, to make sure that it's easy for your loved ones if something happens, and that everyone gets what you want them to have. As you accumulate more assets, then the plan might change. These should be living, breathing documents that are updated as life changes. So you're not stuck with any particular plan. There are people who come in our office who had a will done when they had minor children and had things about guardians and things in there, and then hadn't updated it, but their children have had children now. So like, you need to update those things and look at it every few years. If you have property, if you've changed some things, just reevaluate with time. But you don't need to do anything super complicated. It doesn't have to be super complicated. It just needs to be something so it makes it easier for people, because sometimes going through the probate process can be difficult, just depending on what the assets are and having to do inventory and report things to creditors. So it just depends on what the overall goals are.
So I have one more question, and then we'll do a serious question. So I've been trying to convince my husband to purchase very expensive bags and jewelry, saying that, oh, babe, we can put it in a trust and then our kids can have it. So it will be part of the family. I don't know if that's real. I don't know if that's right information or not, but it's been working. So is that true?
Well, and the nice thing,
go ahead.
Go ahead. If you put it in a trust, you can prevent them from selling it, right? Then they aren't allowed to pawn the stuff.
Right, exactly. I'm like, this will be perfect. Just keep buying me more expensive things.
Yeah, that's one way to do it. You can put anything in a trust. It's like your little red wagon. As long as stuff is in there, it won't fall on the floor. It won't be subject to public scrutiny or anything like that. So yeah, you can put it in there. That might, that's not a complete, false statement, Juliana. You can definitely use that.
Okay. So, okay, we have a serious question, guys.
Wait, question.
Oh, there you go.
I have a question.
Hi, Dick.
Hey, so I need you to Amber, I need you to repeat something. I don't know, my mind was somewhere else just a minute ago. And I'm interested in what takes precedence when I pass away. Is it my will, or is it the trust, or is it what happens in probate?
So you can have both, and they should be consistent. So the trust should be the main thing that houses, if you have assets or whatever you want to go in there, right? Then you have the will that's consistent with the trust. That's just like a catch-all, so that if for some reason whatever you outlined in the trust fails or something happens, the pour over will is going to tell the court, hey, I have a trust here. I already have all of this stuff laid out. There was just a mistake. These things need to go into the trust, or you need to follow what the trustee says. So you want them to be consistent so it's not confusing, and that they are able to put whatever assets or whatever was outside of the trust into the trust, and it can follow it. So normally, for example, Dick, when we draft both. So we'll do the trust, and then we'll do a will that's kind of a catch-all, just in case later on some years pass and something wasn't transferred or something fails. We just try and do both so we can make sure that what you want still gets done.
Okay, I understand that. But so in the situation that I have right now, is that I have what I believe, both my wife and I have what we believe to be pretty comprehensive wills. And we don't have a trust, but I thought I heard you say that even though I have a will, there is something else that could override some of the provisions we have in the
Oh.
will. Did I hear that wrong?
No, I was saying that your will, if you have like life insurance and you say that one person is the beneficiary, then it doesn't matter if the will says, I want all my assets to go to my wife. Whatever that life insurance policy says the beneficiary is, that's where it's going to go. So the insurance company isn't going to take your will from someone that says, hey, I want this to go to someone else. They're going to say, well, this person didn't update their beneficiary form to change that beneficiary. So it's going to go to whomever is designated on that document or in that contract. So that's the only thing that wouldn't change. So if you have beneficiaries that haven't been updated on those forms, and you would want to do that, that's the only thing that the will wouldn't take precedent over those specific beneficiaries you named.
Okay, so I understand that, but how about beneficiaries that I have that are attached to some of the investments I have at Fidelity? I have beneficiaries named there as well.
Those would go
Yeah, I
straight.
thought that was what you were asking, Dick. The beneficiaries trump your will. So let's say y'all went out and changed your will, and I'm just throwing this out as I'll go back to the case study. You changed your will to disinherit Peter Pan and leave all your money to Wendy. Well, if you didn't also change the beneficiaries at Fidelity, and the Fidelity still read half to Peter Pan, half to Wendy, it would be those beneficiary designations that get followed, not what your will says.
Mm-hmm.
Okay, I think I understand. Thanks.
No problem.
Yep.
Alrighty, we have a couple questions that came in through chat. And Dick, I hope I'm part of your will. That'd be awesome.
Well, that goes without saying, Julie. I mean, from the day we
I
met you,
just
we
want the
made
Tesla
a
hat.
change right
That's all I
away.
want, the Tesla hat.
Juliana's responsible for planning the party to celebrate your life.
Absolutely. Lots of vodka there and tequila. This person has a question about how might the revocable living trust be affected by the blue wave?
Yeah, I have a quick thought on that, and then Amber, I'd love to hear her color. Yeah, so a revocable living trust, it's basically you go ahead and title yourself in a trust, but by it being revocable, you can still make changes. And the main reason people do that is to avoid probate a lot of times in different states or to make things easier. I don't see a revocable living trust by itself being impacted that much by the blue wave, but what would depend is how much money you have in the irrevocable living trust. So if you have a revocable living trust with $1 million in it, I don't think it's really impacted by the blue wave. If you have a revocable living trust with $8 million in it, I think it is impacted by the blue wave in the ways that we talked about when we were doing the tax exemption and irrevocable trust planning. And you may want to consider working with somebody like Amber to, change part of it from revocable living to irrevocable. But Amber, thoughts?
No, I think that's 1,000% correct. The IRS treats the revocable living trust like it's you. I mean, it's an extension of you. It only becomes irrevocable at the time that you pass, and then they have to set up an EIN. It's taxed or whatever relevant thing happens, but it wouldn't change because it operates the same way during your life because you have the flexibility to change the terms, restate it, do whatever you need to do. So it wouldn't be impacted. What matters for that is really what assets are in it.
Alrighty, we have a question about the gift tax limit. Do you want to unmute yourself so you can ask?
I just stopped sharing so that I could come over here and try to read the chat too. Okay.
Hey, Juliana, this is Peggy. Yeah, I had a
Hello.
question about, how are you? I had a question about the limits on the gift tax. Were you saying that you're limited to $15,000 per year per person? So if I needed to gift my niece or nephew college money, the max I could give them each year would be $15,000 per year per kid and not be taxed on that?
So for education, like for example, I believe those the 529 plan,
I can't do it because I'm an aunt. I'm not a grandparent or
okay. So,
So I can't do the 529. That's the problem.
okay, so there's a form, right? You probably are gonna have to, please double check with an accountant, because I don't want to tell you something 1,000% wrong, but there's a form, it's a 709 form it's like the gift tax return, and you can do 75,000 over a 5-year period. So if you need to front load it, I think there's a way to do it. So if you need to do a larger portion up front. But go ahead, David.
You're also, there are things that go around the gift tax. So you're always allowed to pay an infinite amount for someone's education, and you're always allowed to pay an infinite amount for someone's medical help. But you can't just give them money to then go out and buy a Ferrari.
Yeah, that won't happen.
So if they go to school and you're paying $30,000 a year to, of tuition, as long as you're making that check out to the University of, Georgia or wherever, it's fine.
Okay, good.
Yeah. And then the other thing I was going to say is that $15,000 per person limit. What that really is above that, you're technically supposed to file the gift tax, but until you've actually given it, in current situation is a lifetime exclusion, so 11.7 million, no money's owed. But let's take a, wealthier family, if they gave $1 million and then their estate grew and, that would count against their lifetime exclusion. So there you go.
Okay, so like if my brother gave me 15,000 this year, then he wouldn't have to.
He would not have to file a gift tax, but if he gave you 30,000, he should.
Okay, good to know.
Yeah,
all right.
And you can get around it. Like if your brother's married, he could give you 15,000, and his wife could give you 15,000.
Interesting. Okay, that's good to know as well. Thank you.
Yeah, and so here's just a strategy out there for like grandparents sometimes. So like they may give 15,000 to their son or daughter, 15,000 to that person's spouse, 15,000 to one of their kids, 15,000 to another kid, and so effectively you've given, like $60,000 to $90,000 to the family without there being gift tax involved.
If he's got that much money, he can give 15,000 to my kids too.
You could.
So we have a couple more minutes, so let's try to get this a little quickly since we have 1, 2, 3, 4 questions. What does it cost to prepare a basic trust and a will?
So we do flat fees because I don't want to keep up with hours. It's not fun. And I don't want people not to call me because they think they're going to get a bill. So we just look at it. So like for a single individual, a will is probably $1,000, but it's not just a will. Like we include the healthcare directive, financial power of attorney, like all the other things that you need with it. It's just a package that people get to pick. And then the highest that we have is like 8,000, and that includes trust. So like it's when it's complicated, and most people don't need that, even though they come in and sometimes think they do. When we look at their assets, talk to their advisor, come up with a plan, most people don't need anything that complicated. So it can range between 1 for a simple will to 8,000 for something much more complex.
To 100,000 if you're trying to do something super complex.
Right.
And then right below that says, Amber, can you set up a trust and will if you live in another state outside of Georgia?
Can I?
Now, you could do the revocable living trust now, but you might have to redo your will when you get to another state. So that's a nice thing about a revocable living trust is you can set that up while you're in Georgia and then move, because I know the person talking about this is moving. But anyway, Amber, I'll let you answer that.
No, yeah, and you can restate it. So like I had a client this week her original trust was in Indiana. And so it can be restated. If you update it later, you can restate it and move the situs or the location of the trust to another state. So you can amend all of those things and update it if you're moving. But you'd want to, what would help, I guess, if you have property in one state, it would be easier if you had a trust that owns it, as opposed to just being a will. Because if you have a will and you say, I live in California and I want my Georgia property to be given to whomever, they're going to have to open up a probate estate in each state that you own property. So the only way to really avoid that is for the trust to open it, because otherwise they have to go from state to state.
The joys of owning a condo in Florida.
You have no state income tax. I mean, and you have the beach. You can't really go wrong with that.
Yeah. All right, Juliana, do we have any more? If not, I'll wrap us up.
Yes, we have 2 more questions very quickly. How do we know if we need a trust? I'm assuming everyone needs a will. Are there rules of thumb or a dollar amount of the state assets or even age that can be used as guidelines?
Okay, so I'd say you know that you need a trust depending on your goals. So mine is from personal experience. I'm not a person who says everyone needs a trust. I'm not a person who says everyone even needs to outline a will, because you might have beneficiary designations that take care of anything that would be in a probate estate. For me, I would always do a trust just because of my family experience. My mother was in probate court for 4 years trying to get permission to sell property. So to me, it's personal. I just don't want anyone to have to go through hiring a lawyer, doing an inventory of assets, because I just saw my mother have such a headache flying back and forth to Massachusetts to take care of an estate. And so it just depends on what your goals are. If you don't want your family members to have to go through that, and you want to be able to tell your beneficiaries what to do with the money, because you can't do that with the will. You can only give things away. But with a trust, you can say, hey, trustee, I want this to pay for college. I want this to pay for this. So you kind of can have some sort of direction. So if that's your goal and you want to make sure that people, one, do what you want them to do, that it's private and not in court, because a will would be public record. So everyone would be able to see it if they went down to the courthouse. And if you want them to have some sort of ease with being able to get the assets, then the trust might be the better route. But if you have assets that it's cut and dry, I have life insurance, there's a beneficiary, I have a Fidelity account, for example, and I have a beneficiary. If you have these things already set up, you might not have to do it. So it would just be a conversation, sitting down and figuring out, okay, what are the goals for each of these assets? Where do I want them to go? Who do I want to have them? And then deciding whether or not it makes sense for you to do, given the goals for your family.
And just as a plug for working with somebody like Amber, having a human to help you make that decision versus just telling a computer what you want, I think is like so much of the value.
We just had another question come in, or 2. So I'm so sorry, it's 102. We have a will. This person has a will, but needs to be updated. Can Amber help update it?
Yeah, of course.
That was the easiest question. And then the last question is to clarify, a revocable trust can have assets from multiple states in it, for example, North Carolina and Georgia, correct?
Yes. So what the person would do is talk to a lawyer or talk to whomever. We redeed the property. So whomever the grantor or grantee, whoever owns it, would sign it over to the trust. And then once the deed is recorded, then it's owned by the trust at that point. And so after the mortgage is paid off, you have a security deed. If you pay the mortgage off and they issue you a warranty deed, they'd issue it to the trust at that point. And so then it would be completely owned by the trust. So you just make sure that it's titled properly and all of that. And then that counts as ownership. That's funding the trust. Or you talk to your advisor if there are other assets you want in there, and they help fill out beneficiary designation forms and change it to the trust. And there are some assets that are better not to go to a trust. So you'd have to talk to someone like David to try and figure out, does it make sense for me to have my IRA with the beneficiary as the trust, or should I just have it a person? You might not want to do that. So you want to talk about what to do with each asset with your advisor too, for certain things.
Yeah.
All righty, those are all the questions for now. Thanks for answering all the questions. It felt like a fireside chat more than a seminar at this point. So I'll let you guys close this out.
Great. All right. Well, thank you guys for attending. Hopefully this has been a good, informative use of time. And if nothing else, just the philosophy behind making sure you're educated and thinking ahead on your financial picture, and then also making sure your wishes and desires are taken through. We're passionate about helping people live a life without financial regrets. And the start of that is to really take the inventory and then think through the plan. And so really and truly, even if you're a very successful person, if you're not intentional with your money, it's not going to do the things you want it to do for you. And we are here to help and want to see you guys live that life, very, very rich life. And hopefully one of our goals this year is to see many more of you in person. I will tell you, after doing this for a year, and we're about a year away from the stock bottom of last year, it's been productive but boring not having more face-to-face interaction. So that's certainly one of my goals, and I hope everybody stays healthy and well, and look forward to seeing you all. Thanks.
All right, thanks, guys. Good job.
Thank you.